with us today. And today's session, everyone will be muted during the webinar. And we ask that when you have questions at any time, I will be moderating through the session with our two speakers, and we will bring the questions forward to them to answer. And they have offered as well their contact details where you can ask questions from them during today's session or off session after today's webinar. We will be and are currently recording the session, and we'll be able to provide you with a copy of the recording along with the slide deck of today's presentation that both Michael and Josie have offered to share with everyone. So with that said, we know that the global pandemic of COVID has had a tremendous adverse impact on our industry, affecting both hotels and restaurants. And we have Michael Nowina, who is a partner at Baker McKenzie in the firm's dispute resolution and global restructuring and insolvency practice groups. Michael advises clients on restructuring and insolvency matters, including bankruptcies, receiverships, and the employment and pension law issues that arise on corporate liquidations or restructurings. From BDO Canada, we're pleased to have Josie Parisi join us. Josie is a partner at BDO Canada Limited in the firm's corporate restructuring practice. Josie advises both companies and lenders regarding their options in insolvency situations. So for Josie and Michael, thank you for joining us, and I'll have you take it from here.
Okay. Thank you very much. So what Josie and I are going to do is split up the presentation. We're going to start off by talking a little bit about where the industry is at and what we're seeing. And we're going to talk about our experiences with advising clients and advising lenders and landlords. And then we're going to move into some specifics about what alternatives to bankruptcy look like under Canada's system. So with that said, I'm going to just talk a little bit about where we are and contrast that with the United States. We're in an interesting situation from my perspective because we are obviously going through an unprecedented situation with COVID. And unlike in the United States, which, as this headline from the Wall Street Journal reads, they're already seeing, record retail insolvencies and closings of retail businesses. The insolvency statistics from Canada are showing that wave hasn't yet hit us. The insolvency statistics in Canada, and this comes from the Office of the Superintendent in Bankruptcy, says that insolvency filings in Canada were actually 42% lower in August of this year as compared to 2019, which is a pretty astounding statistic when you think about the huge economic disruption that we've experienced because of COVID. How do we explain this statistic? I think there are two factors. And this is my own view. It's not backed up by any statistical analysis, but the incredible government support that has been provided to consumers and to businesses have had a significant impact in keeping insolvency rates as low as they are. The second significant factor has been lenders, landlords, and other significant creditors have both been encouraged to forbear and not enforce. And they've also, in a lot of ways, been prevented from enforcing because the court system, for a large part of this pandemic, has been effectively shut down. And even if they were so inclined to enforce, they didn't really have the capacity to do so. But of course, we're now coming to a situation where both government support is ending and the court system is opening back up again. And the real question is, what is going to happen in the next 6 to 9 months? So just to give a quick overview of where the hotel industry is at, I mean, as many of you will know better because you're living this experience, the rapid imposition of the travel bans and the public health shutdowns have had an enormous impact on travel, both airline and domestic travel. There were huge declines in leisure travel, huge declines in business travel, which has created enormous pressure on the hotel industry. Um, the forecasts that we've looked at, and we're happy to share with you some of these reports if you're interested in them, but there's been significant revenue declines across the board in 2020. It's not projected to get back to where we were in 2019 in terms of the RevPAR and the occupancy rates until 2024. So a general return to normal is expected, but it's not going to be quick. My own personal view is that I think business travel will be very slow to recover because a lot of businesses are realizing, for the first time perhaps, that video conferencing options like this can be a substitute for a lot of business travel that they were doing previously. I think fly to destinations and the resorts that are and hotels that are centered around fly to destinations are going to have a harder time recovering as opposed to local hotels and resorts that can draw on a local base of people. And that obviously won't change until the airline industry recovers. So in terms of restaurants, again, we all know exactly what happened because of the COVID shutdown, and our ability to go out to restaurants was pretty well restricted. And in terms of full service restaurants, again, the projections are that people are going to want to resume dining at restaurants. There's going to be a lot of pent up demand among business people to entertain their clients, and just pent up demand generally to get back to more normal societal experience once people are able to do so without the health concerns. So in terms of the fast food restaurant industry, I mean, in a lot of ways, they were better positioned to weather the effects of COVID-19 because they a lot of times would already have delivery and takeout services that were able to sustain them. And I think this is, if there's a brighter spot, it'll obviously be in the fast food sector of the restaurant area. So that's an overview of where the industry is. What I thought I would do now is pose a question to both Josie and myself about how landlords and lenders have reacted and are reacting to the pressure that businesses are under. So I'll turn it over to Josie for her thoughts, and then I'll offer mine as well.
Thanks, Michael. I'm having a little bit of audio trouble on my side, but I think you've just handed it back over to me. So if I do experience audio trouble again, I'll let you know. So my experience to date, at least on the lender side, has been that they have been really understanding and patient with companies, understanding that a lot of the stress and financial issues that are being experienced are not through any doing of the companies, that it really is the economic environment. And until that becomes under control, these financial issues will continue. And so essentially the lenders have provided a lot of deferrals, repayment deferrals and interest referrals. But some of those are now coming to an end. Some of the government-based lenders Their mandate was to defer until September. Some of those deferrals are now coming due. My discussions with those lenders are that they will continue to provide concessions to the various companies, provided that the requested concessions are reasonable. And they're also looking for a solution to be brought to them as opposed to the lender providing the solution. So if there is an ask of the lender, either whether it be continued deferral of principal or interest, or deferral of simply the principal or the interest, those asks should be made. In terms of the in terms of the landlords, my experience has been that landlords who have tenants that are essentially in the manufacturing space have not really been favorable towards the Canada Emergency Commercial Rent Assistance Program, feeling that those industries are continuing to operate and they should be able to pay their rent. I find that the landlords who are dealing with people in the hospitality industry, specifically for restaurants, they're much more lenient with their tenants, and they are willing to apply for funding. Michael, what's your experience?
Thanks, Josie. So my experience with lenders and the lenders that I've spoken with is that the approach that they're taking is a batten down the hatches approach, in that they're expecting a wave of problems coming down the pipe, and the name of the game for those lenders have been forbearing on loan covenant defaults and what have you, while at the same time they're attempting to get as much information they can about their borrowers in order to gauge which of the borrowers frankly is going to survive the next year and which of them are not. The other factor that I think has been a real one for a lot of lenders is that they don't want to be the first major financial institution to start enforcing against small and medium-sized businesses that have been adversely affected by the pandemic, because they don't want that press. But at some point, one of the lenders is going to start being more aggressive, and then they'll all follow suit. So it's really just a matter of time. In terms of landlords, I mean, our experience was that they weren't very enthusiastic about the support program that the government put in place. I think Doug Ford's announcement in May, which basically boiled down to get your act together, landlords. If you don't react properly to the pressure that small businesses are under, you're not going to want to see what I'm going to do to you. And we were negotiating with a number of landlords at that time for one particular restaurant client, and it made a huge impact in getting the landlords to come around to being on board with the program. Now that program is ending, I'm not sure that landlords are going to be that helpful going forward. On the other hand, the larger ones, I think, have realized that there is an unprecedented situation here, and that they have to support their tenants in order to support their own businesses.
Michael, we have a comment from the group here that says that the understanding is that landlords are much more predatory in relation to independent operators. Isn't that the prevalence, and are you expecting it will worsen?
So it's a good question, and I mean the reality is that smaller tenants have a lot less negotiating power than a large tenant will. That's just the fact of the matter. What I would say is it really depends on who your landlord is. Like I said, the larger landlords that we have been dealing with seem to have a more sophisticated view about the situation that they're in and what they need to do, rather than smaller landlords who are effectively stuck on, here is our rent and why are you not paying it? And moving them off of that, it has been more difficult. So I wouldn't disagree with the comment that was made that smaller tenants have a bigger problem in dealing with their landlords, but I would say it's still worth trying, and a lot will depend on your landlord.
And also their ability to put another tenant in the premises quickly.
Yeah, that's a bang on point. All right, so moving on. So avoiding bankruptcy. We're going to get now into the substance of this presentation. So our system is intended to encourage businesses and individuals to restructure rather than simply look at bankruptcy. Restructuring is always a better option than bankruptcy. And our system is designed, as I said, to sort of encourage people to at least attempt it. It saves jobs, it maintains customer relationships, it maintains, supplier relationships, and there is a stigma of a bankruptcy that attaches both to an individual who goes bankrupt, but also to a company, which obviously means that the business is going to be shut down and the assets liquidated. One of the questions that we had before this presentation from one of the members was from an operator of some hotels in Northern Ontario who is dealing with a severe impact of COVID with occupancy rates of 20 to 30%. And their question to us was, what can we do to save our business? What are our options? And what we would say is that there are three basic options. We're going to focus more on 1 and 2, and we'll touch on the third one just a little bit now. So the first option is you can always informally have negotiations and discussions with your creditors. And a lot of times, businesses are able to come to what are called informal arrangements with their creditors to sort of keep the business going and make compromises. And Josie's going to touch on that a little bit more. The second broad type of option is a formal proceeding called a Division 1 proposal under the Bankruptcy Act. And this is a formal process that basically engages legal protections to say, this business can't continue as it is, but we're going to try to make changes to that business so it can continue. And we're going to offer the creditors as much as we can offer them in the circumstances of the business. The third option is called the Companies Creditors Arrangement Act. It's effectively very similar to a proposal, but it's really intended for large companies. There's certain debt thresholds of over $5 million that you have to have. It's much more expensive. When you think of a large company undergoing a restructuring, they use the CCAA primarily. So before I turn it over to Josie, you can see what we put in bold there on our slides. What we would say is a mistake that a lot of times gets made by small businesses and small operators is, putting more money into the business themselves in an effort to turn it around. And that's not necessarily a good solution if the underlying problems of the business continue, because you're just kicking it down the road. The second mistake that we see a lot is waiting to see if things get better and hoping things will get better. And again, a lot of times they don't. But what you've done by waiting is your situation is worse, and your the flexibility and the options that you might have had to fix things is now gone. So with that said, I'm going to turn it over to Josie to go a little bit more into detail about these options.
Thanks, Michael. So what we have on the screen is just a chart that compares an informal and a formal restructuring. What I mean by formal restructuring, and what Michael has already alluded to, is that it's a legal process and that it is dictated by the Bankruptcy and Insolvency Act. Whereas in an informal restructuring, it's essentially you negotiating with your creditors individually outside of a legal process. So depending on the circumstances, it might be possible for a company to contact its creditors and negotiate with them directly. It might be one creditor that you really need to negotiate with as opposed to the pool of creditors. And in that case, it might be it might be easier and more successful to be able to negotiate with the one creditor. The more creditors there are, and the more in the different classes those creditors might be in, whether they be landlords, banks, trade creditors, the more difficult it's going to be to try to herd up all of these different creditors to make concessions with each of them individually. A couple of things to note when considering going down the informal path is, first of all, that your creditors are not obligated to negotiate with you. If they do, however, agree to negotiate with you, what you offer them should be reasonable. If the ask is not reasonable, something like, can you forgive the entirety of the debt, it is likely not going to be successful. And in addition to it not being successful, it's an admission that you are insolvent, and that fact could be used against you in the future if they decide to enforce against you. If you are looking to change your repayment structure, it's likely that your creditors will want an opportunity to look at your financial statements and your projections in order to determine whether the concessions that you're asking for are reasonable. So you should be prepared for that and be prepared to open up your books so that they can understand where you are financially. In addition to these items, one of the main disadvantages of an informal proceeding is there's what we call a stay of proceedings, which means that your creditors are stopped from taking any sort of enforcement action against you, such as your lender calling your loan or obtaining judgments against you, or your landlord locking you out of your premises. The main benefit, however, to an informal restructuring is that it's less expensive than a formal filing. It can be done fairly quickly, and it can be done by you and probably your legal counsel. By contrast, a formal proposal is essentially a contract entered into between you and your creditors, which results in the structuring of your debt and an orderly repayment of that debt in accordance with terms. And this contract is agreed to by both you and agreed to by you, your creditors, and the court. A couple more things about proposals, and we'll get to them in a bit more detail in a second. Firstly, that a proposal is very rigid in terms of its time deadlines. There are certain documents that need to be filed within certain timelines, and if those are not met, it will result in a bankruptcy. So there is some risk if you're not organized and prepared. The other thing is that you will require the use of an insolvency trustee in order to file a proposal. You cannot do it on your own. And going back to some of the comments that Michael made previously about the industry sentiment and the sentiment of landlords and lenders, given the current economic environment that we are currently in, proposals have a much greater chance of success than they have in the past. All right, so proposal usually results in a compromise in the amount that is owed to your creditors. And the proposal outlines when the payments will be made. So it could be a lump sum payment of the amount of the pre-proposal amounts, or it could be payment of a portion of that debt over time. There are no hard and fast rules about when payments will be made to your unsecured creditors for those pre-proposal obligations. It essentially is limited to your creativity. So I've seen proposals where there's a lump sum once the court has approved the plan. I've seen proposals where payments are made over time. I've seen some where there's a bullet payment at the end of a period. So it really is limited to your creativity. In a proposal, unlike a bankruptcy, the company will continue to operate, and the company operates with its current management while it continues to restructure. And we call that a debtor in possession filing, because everything continues as it was pre-proposal, including employment of your employees. You're staying in the same premises, and you continue to operate your business as you were prior to the proposal. During the term of the proposal, the affairs of the company are monitored by the trustee, who will report to the body of creditors and the court if there are any material changes to the operations or the company's ability to meet the terms of the proposal. So if you are unable to make the scheduled proposal payments on a specified date, then the trustee will have to report that to the creditor base and to the court. One of the great things about a proposal is how easy it is to initiate the process. A proposal is often used by companies when they need to stop a creditor from acting against them. So for instance, if your landlord is threatening to change the locks to lock out a tenant, we can file what's called a notice of intention to file a proposal. And once that document is filed with the Office of the Superintendent of Bankruptcy, the creditors are stayed from taking any sort of action against you. Can I get the next slide, Michael? Okay. So proposal can be started in one of two ways, and I've alluded to the first one, which is the filing of the notice of intention to file a proposal, which again, like I said, is a short document. It's filed with the it's e-filed with the Office of the Superintendent of Bankruptcy, and it's mailed to your creditors. Once the document is received by the Office of the Superintendent of Bankruptcy, the stay is in effect, and you can serve it upon the creditors who are trying to enforce against you. Like I said, there are some stringent timelines. Once the notice of intention is filed, there are some filing requirements, the first of which is filing a cash flow with the Superintendent of Bankruptcy within 10 days of filing that notice of intention. And it's usually for a 13-week period. Then you must file with the Office of the Superintendent of Bankruptcy and your creditors a proposal within 30 days. If you can't file the proposal within 30 days because you need more time to develop your proposal and talk to your creditors and really understand how to fund a proposal, whether there can be a refinancing to assist with a proposal, you can ask for an extension of time. You can ask for up to 5 extensions, with a maximum of those extensions being 45 days each, and the total of those extensions cannot exceed 6 months. So from the date of filing of a notice of intention to file a proposal to the date that you file, you could get up to 6 months' time to develop your proposal, and your creditors are stayed from taking enforcement action against you, provided that you continue to pay your obligations as they come due.
Josie, can I just ask you a question?
Sure.
What's the role of the insolvency trustee helping the company through this process?
Yeah, so the insolvency trustee is really there as a guide to help the company understand its options and to help them develop the plan in terms of understanding what the requirements of getting a successful proposal, reviewing the company's financial statements and its financial condition to really understand whether a proposal can be made. Sometimes when we take a look at a company that wants to file a proposal, we'll see that the proposal might not be viable just because there really is no business on the other side. We can also, the role of the proposal trustee is also to help identify, sources of financing, other options to them, such as divesting of certain assets to free up some cash, divesting of certain divisions of their company in order, again, to free up some cash, understand where the cash drain is, and helping to relieve that in order to produce a company that is healthy on the other side of a proposal.
And so, Josie, just to ask at this point, because many businesses are finding that they're at the junction of the road,
Yeah.
where do they turn? Do they turn to an insolvency expert, or do they turn to a lawyer, or do they do both at the same time? Because many on the call today don't know where to turn. Where would they turn to first?
I would say either or. Oftentimes, these types of proceedings will start with someone contacting their lawyer because of somebody taking some sort of enforcement step against them. You know, the landlord is threatening to lock the doors. In those types of situations, companies typically call their lawyers to understand their rights. And then from there, the lawyer will refer in an insolvency professional. Other times we find that we have our own clients within our own accounting firm that have talked to their accountant, and the accountant says, well, you should probably talk to one of our insolvency professionals. So it really is dependent on your particular situation, whether you have a strong relationship with your legal counsel, or if your accounting firm has an insolvency division, or you know an insolvency professional. I typically suggest that speaking with your lawyer is probably the best first step. Michael, would you agree with that?
I would, of course, being a lawyer. I think that's a great idea. But what I would say, there's two reasons why it's usually a good idea to speak to a lawyer at some part of the process if you're going to do a proposal. Number one, lawyers, your communications with your lawyer is obviously privileged, and no one can get to know what those communications were. The second reason is that proposal trustees have a dual role. One of their roles is to help you go through a proposal process and hopefully a successful proposal process. But the proposal trustee also has a duty to the creditors, and they're going to be reporting to the court. And so they have that dual role, whereas a lawyer that you speak to is fully and 100% on your side and is going to give you advice to further your interests. And usually there's no conflict and everyone's working in the same direction, but sometimes that can make a difference. So it's always good to speak with a lawyer, I would say, but the process is intended to be a cooperative one and everyone works together as much as possible.
Thank you.
Okay. So I was speaking about the two methods to start the proposal. We talked about the notice of intention, and then the second way is basically to skip the notice of intention filing and go straight to filing a proposal. I see this a lot less often just because companies need immediate relief from the pressure of their creditors and some time to develop a proposal. So once the main deadlines have been met and there's a proposal ready to present to your creditors, that proposal gets mailed to the creditors along with the Office of the Superintendent of Bankruptcy, and then a meeting of creditors occurs. So that's when your creditors have the opportunity to sit in a room with you or a Zoom call with you, as we are doing more recently, and discuss your financial affairs and really understand the proposal and ask you some questions. And then at that meeting, the creditors get to vote on the proposal. So they will say yes or no in terms of the proposal based on some voting criteria that Michael will discuss. If the answer is no, that they do not believe that the proposal is acceptable, there is deemed bankruptcy. So what we do in order to try to avoid that is we take what's called a straw vote at the meeting of creditors, and we ask the creditors before the actual vote is taken to give us a show of hands as to how many of the creditors are willing to accept the proposal. If we find that the terms are not sufficient, that they need the pot sweetened a bit, we can negotiate with the creditors at that meeting of creditors. And if we need more time, we can adjourn the meeting and go back and regroup. So you do need your creditors to agree. Once you have the creditors in agreement, it goes to court for court approval. And once it is approved by the court, it is legally binding. The next slide, Michael, can we go to slide 14? On the benefits, thank you. We discussed previously with Michael the benefits of a proposal. And first of all, as I've already mentioned, there's an immediate stay from your creditors so that your creditors cannot enforce, and you get that release from that pressure that's likely been building. It can help you terminate certain contracts that are onerous to the business. We had a situation recently where there was a very onerous royalty agreement that we were able to terminate through the process. The proposal also provides you protection from your creditors, wherein it stays your creditors from terminating agreements with you because you are insolvent. And part of the proposal legislation allows you to sell certain assets that may be redundant or might not be in use, and you could use those funds to help with the proposal, fund the proposal. Also within the proposal, you might be able to try to get new credit from either your existing creditor or for another lender to help you restructure your affairs. And now I'd like to turn it over to you, Michael.
So I'm going to go quickly through the next few slides in the interest of time. What I'll say is that there are some specific requirements. You have to offer more than the creditors would get in a bankruptcy. There are certain amounts that you have to pay to the government and to employees, and that's just a statutory requirement. The voting procedure is pretty straightforward. You've got creditor classes. You can have an unsecured class. You can have a secured class. They have to vote in favor, both in number and in value. The one thing that I'll say before we move on to just talking a little bit about what actually bankruptcy looks like is that there's something called a holding proposal, which had fallen into disuse, but has been effectively brought back and blessed by the Office of the Superintendent in Bankruptcy. And a holding proposal is effectively just a placeholder that once you file this proposal, you don't necessarily have to have a vote on it right away when the economic situation is so uncertain because of COVID. And so that's an option that does exist. I thought it's worth mentioning. So in terms of bankruptcy, this is more just to give you an indication of what happens if you can't restructure. Bankruptcy means you're liquidating assets, and a trustee in bankruptcy effectively takes over the business from the directors and from the owners. And the role of the bankruptcy trustee is to effectively distribute the assets in a waterfall where secured creditors and the government is on top for certain things. You have what are called preferred creditors underneath, and at the very bottom you have unsecured creditors, which are usually trade claims and what have you. There are what are called inspectors that are appointed by the creditors to supervise and give directions to the trustee, and that's effectively how the bankruptcy process works at a sort of very high level. So in terms of looking at the benefits of restructuring versus bankruptcy, I think, as you can tell from the tone of this presentation, Josie and I are both of the view that restructuring is a much better option in most situations than a bankruptcy. It gives you the opportunity to continue your operations. It's a reasonably flexible procedure. you remain in possession, you remain in control. You can sell assets if you need to, but you don't necessarily have to sell assets in a restructuring if they're important for your business. It's more favorable for your creditors to restructure because, by definition, you have to offer them more than they would get in a bankruptcy. But selling assets through a bankruptcy trustee rarely generates the best value. Because they're being sold by a trustee, everyone knows that they can get them for a discount, and they're usually sold on a very short time frame, which also is not conducive to getting a good result. And a stay of proceedings for all creditors. Josie alluded to this before. When you do a notice of intention, NOI, to make a proposal, in most situations, you can stay both your unsecured and your secured creditors. In a bankruptcy, only unsecured creditors are stayed, secured creditors are not. And again, that's just a feature of how the bankruptcy process works. So we've already touched on landlords, but I'll turn it back over to Josie to talk about where things are at with the CERCA program.
Thanks, Michael. So I'm sure everybody on this call has probably heard of this this legislation or this program. Basically provides relief to tenants who operate small businesses from the rent. Today is actually the last day to apply, and the onus is on the landlord to apply for the relief. My understanding is that there hasn't been a whole lot of take up on this program. I do have one client who they have 400 locations, and it is the same landlord for all 400 locations, and that landlord has been quite proactive in applying for this program and providing the relief to the tenants. There's a two-part test. The landlord has to reduce the rent by 75%, and the tenant has to have had a decline in their pre-COVID revenue by about 70%. So it might not be very easy to qualify if the landlord is not willing to take a concession, or if your revenue decline hasn't been as significant as 70%. So essentially the way it works is the government gives the landlord a forgivable loan for 50% of the rent. The tenant is required to pay 25% of the rent, and the landlord absorbs the other 25% of the rent. It's essentially how that program works. And as we've already indicated, today is the last day for the landlords to apply. If we can go to the next slide, Michael, on other relief that's available. So I'll run through the next couple of slides very quickly, just in the interest of time, so that we have some time for discussion. SEBA and the CEWS, one being a SEBA program essentially is a interest-free loan for small businesses to a maximum of $40,000. Those monies have to be spent on operating costs that cannot be deferred, such as rent or payroll or insurance. It cannot be used for payment of other lenders' debt. The loan can be up to $10,000 of it can be forgiven if the loan is paid by December 31st, 2020, and the maximum amount of the loan is $40,000. The other program noted on there is the wage subsidy. The wage subsidy calculations have gone through migration. They've changed again. It allows for up to 75% of your wages to be subsidized by the government, and is an effort to have businesses retain their workforce. The rules on how to calculate this are very technical, and we can run a whole session on that alone, so I won't go into that. But if there has been any sort of revenue decline, you are entitled to a base subsidy. There's a top up to that base subsidy if your revenues have declined by more than 50%. Next slide, please. The next three programs are essentially loan type programs. The first one being the BDC co-lending program. This is a program where BDC, along with your primary lender, can lend you up to $12.5 million. There are a number of eligibility criteria, but the main one is that your business had to be financially viable and stable before COVID. So if you were in special loans or you were in default of your loans prior to COVID, you will not be eligible for that loan. These loans, the lending criteria for those loans are established by your primary lender. The next loan is the BCAP loan. Those are business credit availability programs, which are up to 6.25 million. Again, those are provided by your existing lender, and they're guaranteed by the Export Development Bank of Canada. And they provide your bank some comfort that if they give you the money, if they lend you the funds, that they will be recovered. The banks will look to their normal lending practices and criteria to ensure that you're creditworthy. Again, similar to the other loans, the funds are meant to be used for operating costs, and they cannot be used to repay or refinance existing debt. And the last item that we have there is the Regional Relief and Recovery Fund. There are a number of these funds, and eligibility depends upon where you are located. So we encourage you to take a look at which programs you might qualify for. And then if I can get the last slide, Michael. So the last slide, the conclusions. So yeah, essentially our final thoughts here, and as Michael has already said at the beginning of this presentation, injecting more money might not be the best solution. We believe that you should be proactive as opposed to waiting for things to recover and waiting for someone else to bring you a solution or to make that first step. Someone enforcing against you is too late. So be proactive. And lastly, we talked about a lot of different topics today, and we really only scratched the surface. So we recommend that if you want to explore a proposal, what the implications are, or any other topics that we've talked about here today, please feel free to contact Michael and or myself. Our contact information will be made available along with this presentation by the association. So I guess now we can open it up to some questions.
And I know that we had one question that was sent to us before the presentation we haven't addressed yet, which is a franchise question relating to what can I do to get out of my franchise? And the short answer to that question is that there's nothing about COVID per se that allows you to get out of your franchise agreement. You'd have to obviously review your franchise agreement to see what your legal rights were. It's possible that there's a force majeure clause that might provide some relief to you. It's possible if you're still a new franchise and within 2 years that you might have some statutory rights under the Arthur Wisher Act that you could use to get out of the franchise. But again, there's nothing specific about COVID that allows you to get out. What I would say is that our experience representing some franchisors is that they are generally attempting to preserve their franchisees' businesses. And so, royalty relief on advertising programs or property improvement programs required by the franchisor in normal times are being relaxed. It's not to say that every franchise owner is having the benefit of those types of programs from their franchise, but they are out there, and it's always worth speaking to your franchisor before making any decisions. I'm also aware of at least one franchisor that is actively looking for restaurant locations to acquire. Some businesses are looking at this as a business opportunity to grow. So there may be options to sell your business, or at least leverage your location if it's a good location to to mitigate your situation. Fatima, I don't know if we have any other questions so far.
We do. They've responded so positively to all the information, and there really is an overabundance of information that's been made here. This slide deck is going to be available to all. I have a question. We did have a pre-question from the owner that operates 7 hotels and motels in Northern Ontario. And he's added a bit more information here that he'd like some clarity on. He states that 4 of the 7 hotels and motels properties are doing fairly well, marginally profitable, but 3 of his properties are in crisis mode. They may need to shut down these properties and declare bankruptcy. Could you shed some light on what some options are? The feeling is that what will the lender do in these trying times with closed or non-operating hotels? Advice for our member here?
Sure. So I'll go first from a legal perspective, and Josie can add her comments from a trustee perspective. So it's hard, and my firm doesn't like me to give advice in a vacuum of information. So what I would say the best solution is perhaps to reach out to us, and we can have an offline conversation. But depending on the legal structure, for instance, if the hotels are owned in separate companies, so they're all isolated from one another legally, then shutting down certain locations while leaving other locations open might be a viable option. You obviously also have to look at your loan agreement and understand what your exposure to your lenders are on those various hotel properties. So what we generally do when a client like this comes to us is that we do sort of a corporate checkup and figure out, what are the assets, what are the liabilities, what are the legal obligations, and then once we have that picture of where things are at, then it's a much easier process to say, okay, what can we do? What are the viable restructuring options here? And then that's usually when, as a lawyer, I would bring someone like Josie in to help with the process. And so with that said, I'll turn it over to Josie for her comments.
I would echo Michael's comments that probably needs to do a little bit more digging to understand the legal structure of the organizations and what kind of debts are in the company and if they're in separate entities. But one of the options that might come out of the discussion might be, as we've discussed already, a potential proposal. Selling some of the assets in order to fund the rest of the company during this period of time. Another option might be to sell the underperforming assets. But again, providing any sort of legal advice without understanding the full situation is probably not the proper advice at this point. And so I would invite you to contact either Michael or myself to get more details so that a plan can be developed to assist with the situation.
Okay, thank you, Josie and Michael, and we'll certainly make both of your contact information available by email and by phone. We have a question from an operator. In their experience, most small to medium businesses will have personal guarantees in place from their owners. How are those impacted by bankruptcy?
That's a good question, and the short answer is that if there's a personal guarantee, it's not affected by a bankruptcy of the corporation. However, if it's an individual guarantee and the individual files for bankruptcy, then that guarantee is effectively discharged by the individual's bankruptcy. So just so in case if my answer was too lawyerly and long-winded, a corporate bankruptcy doesn't discharge a personal guarantee. A personal bankruptcy will discharge a personal guarantee.
So if there's a shortfall in a bankruptcy and the amount of from the sale of the assets doesn't satisfy all of the lender's debt, they may enforce on the personal guarantee. And that's something that could be discussed with your lender if you're cooperative in helping them realize on the assets and whatnot. But as Michael said, a corporate bankruptcy does not discharge your personal guarantee. Fatima, you're on mute. We can't hear you.
See how we can always, thank you, lean on lawyer and insolvency. When one doesn't have clarity, the other adds a little bit more. And today's session, you have added some clarity to many operators who are struggling during these difficult days. And we thank you for your time, Michael and Josie, and your expertise. To those that have joined us today, thank you. We will be sending an email out with the recording and Josie and Michael's contact information. And thank you again, and please stay safe. Thank you all for joining us.
Thank you, everyone.